Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for
Hi, everybody. Happy birthday to Courtney yesterday. And Beverly tomorrow or midnight tonight. Congratulations. Happy birthday. I love you both so much. Courtney, I'll sing to you in a minute. And Beverly, I'll sing to you tomorrow. If that works. Hi, Adam. Hope you are well. I've been thinking about Texas a lot today. Seriously, obviously, our thoughts and prayers go out to Texas. But, Mac the Knife, you have a life that revolves around me. No, that's all I can think of if you manage to jump into the live less than 3 minutes in. No, I'm just joking. What are we going to do? We're going to watch some court. It's going to be great. I did a little scan through. We are at, this is my Friday. I'm off for a couple days. And so regular scheduled evenings will commence. I will work day and night for you, like I always do, but extra because I'll be home during the day. So, I'll be recording all the court that I can possibly fit onto my little computer, and then bringing it back, big back, to y'all, the way that we always do. So confusing to explain to somebody if I ever choose to, but that's okay. We don't need to. We have our little crew here, and I'm so happy that you're here. Anyways. Oh, Bill, it's okay. Did Colin just end anyways? I actually have no clue. I have been running off my feet. My Fitbit says, that is a lie. Lie detector test has determined that is a lie. Anyways, let's get us going. We're going back in time. Why? Because I want to. And it's really the only way I can right now. Unless you know of a time machine that I don't. And if so, go ahead and share that out with us. Would ya? Could ya? Maybe? Baby, please? Judge Brian Kirkham, we miss you too.
Seventh Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2024-1372 DC, Zachary Conley versus Athena Couch. Today is Monday, November 25th, 2024 at 10:31 a.m.
Court will note the appearance of Mr. Kelly on behalf of the plaintiff, defendant appearing pro per. This matter is before the court on the defendant's motion. In this matter, it appears from the motion that it's for reconsideration. Ms. Couch, you can proceed with your motion.
Okay. I have filed this motion for reconsideration of the parenting time given.
Oh, fuck. So I'm saying that because I now remember the second I heard her speak, the literal second I heard her speak, she's going to allege that he's into some weird diaper fetish. It's weird. They came to court live, and there's lots of channels that have done the follow-up. I think we watched it at the time. Anyways, this is not what this whole day is. I scrolled through and there's many cases. That's why I picked it. But I do recall now. So fuck that. I feel bad, but just know that it's not all like this. And honestly, her hair looks terrible for court. What is this angle? What is this angle, people? Fix your angles.
To the plaintiff, I don't believe the current order is in the best interest of the minor children, Amelia Margaret Conley and Evelyn Ann Conley. The plaintiff and his family's primary concern is money and control. In an effort to avoid paying child support, attorney Michael Kelly stated the plaintiff wanted primary custody of the children who have been under my supervision and care their entire life. It is apart from weekend visitation with grandparents. I wholeheartedly and unconditionally love my children, and I made it abundantly clear I did not want to put my children in daycare. I believe that having a positive parental figure is important for the development of children ages infant to preschool, to encourage an appropriate, safe, and consistent environment. I have stated in this motion how I aspire to feed the minor children healthy foods, more specifically nourishment for their bodies. Both of my children are in the 90th percentile for their height, and no one has mentioned how smart the children are. I, the defendant, have been reading books to the children since they were a week old, and we read books before bedtime and before nap time. They also know an abundance of nursery rhymes and songs. Excuse me. The minor children, who are 2 years and 8 months old, know the alphabet, numbers 1 through 15, all their shapes and colors. They also can say over 200 words, almost speak full sentences, and according to pbs.org, my children can read. Excuse me. You need to go play, please. I do think it's important to lead by example, and though my morals were in question due to lack of up-to-date tags on my vehicle, I am a good person. I opened doors for others, and most are greeted with a smile. I taught the minor children to say please, thank you, excuse me, and to cover their mouth when sneezing or coughing, and we do not judge others. If you are kind, kindness is reciprocated.
Oh, I wasn't going to comment. I was just going to let this play because, like I said, this is a whole different case. I'm sure another channel has done it much better than I have. But, one of these things is not like the other. Like, when you're making lists like that, is it only me that sounds off to? Like, I open doors for other people in the same sentence as whatever she said next, and I already forget because my brain's fucked up.
Excuse me, you need to back up and go play. Excuse me. No. I'm sorry. No, you cannot be in here. You need to go play. I'm sorry. Honey, no.
Oh my god, the cringe. I remember this so much.
Anything else, Couch?
Yes, I'm sorry. I had lost my place. We do not judge others. And even then we do greet others with understanding. The plaintiff's character is in question, and I have asked the plaintiff for an explanation regarding him watching videos of children peeing in diapers, and even more so the videos of children and babies he was watching have enemas done to them, all of which he had no response or flat out lies. I can prove, I mean, I have evidence. I'm a mess. I apologize. If the plaintiff's family The plaintiff's family was also made aware of the plaintiff's sexual fetish of diapers because, quite frankly, it was appalling and I was concerned. Lori Putnam, the plaintiff's mother, stated on June 18th of 2022 that the plaintiff had started stealing his half-brother's diapers to use at 15 and that she consulted her husband and it wasn't an issue. She then consoled me and offered to give me a hug and then tell the plaintiff the next morning within earshot of where I was reading to the children that I, the defendant, was the problem. This is just one of the, stop please, stop. This is just one of the many instances that I have felt psychologically manipulated by the, stop please, stop honey, by the plaintiff's family. It is my belief that the plaintiff and his family's intent to manipulate the court and in altering information and therefore putting the plaintiff in a fatherly light. Unfortunately, this is contrary to what I have witnessed, and the plaintiff has had maniacal episodes where he would run through the house, shaking his head with his tongue out, and he would crawl across the floor. He has crawled across the floor of the minor children's bedroom, crouching and staring at me. As I stated in the motion, he frequently bangs his head into a steering wheel. And when asked why he was doing this, the plaintiff expressed to me that he has a hard head and that he used to bang his head into his, stop please, honey, go play for a moment. I cannot, okay?
Ma'am, the kids should not be hearing all this. You're gonna have to remove them from the room, please.
I don't have another option.
Well, you go into a different room. There's gotta be another room you can go into to have this heard. If not another room, go outside or something.
Okay. Okay.
Hi, Nigel. Thank you so much. Oh my God. Ridiculous. Ridiculous! Wow, full cringe achieved. Absolutely full fucking cringe achieved. Oh my God.
I'm very sorry. I do apologize for being so all over the place. Okay. Plaintiff attended Lakeview schools, and it does surprise me that no administrative intervention was done with the plaintiff's parents. I do believe that plaintiff and his family are not positive, kind-hearted people who have the children's best interest in mind.
Adam for 2 months and Courtney 19 months. Bing bing bong. Happy birthday, my friend. Annoying. Sorry, my daughter's texting me about something. This whole situation, by the way, hiding behind a phone, I was just talking to it. I'm talking to the phone. I'm talking to the phone. Ed. Parenting in the 21st century. All right? While live streaming. Duh. How else does it get done?
On the contrary, malicious, manipulative, and falsifiers. I am here pleading you to take immediate notice of how the plaintiff's behavior is dangerous and potentially damaging to the minor children, Amelia Margaret Conley and Evelyn Ann Conley. It is imperative that the visitation between plaintiff and the minor children be supervised. Furthermore, no overnight visitations. And I am extending an alternative option for parenting time. Monday, 4 to 8 p.m., Wednesday, 4 to 8 p.m., and Saturday, 11 a.m. to 9 p.m.
Is this lady the person I exchanged my services for money? She sounds like she's handing me a work schedule, and I'm not fucking into it. If you don't know, this whole case has been covered by a few people. Spoiler alert. Literal spoiler alert. Spoiler alert. Casey Carey, hello. Spoiler alert. the judge denies these motions in person. And I think she goes to jail. I'm almost positive, but I might be wrong on that part, but I'm almost positive that's what happens. Because she won't produce them. And B, I've been worried about you in Austin. Worried, so worried.
That's everything.
Okay, anything else?
No.
Okay, Mr. Kelly? I have reviewed your answer.
Your Honor, then you're aware of the burden that must be carried. Palpable error has not been shown this morning, Your Honor. These are the same issues that have been brought up time and time again throughout this case. We had a hearing, evidence was presented, no palpable error has been shown this morning. Your Honor, we request the motion be denied. We'd also request attorney's fees for having to respond to this motion because it is not well-based in law or fact, and is devoid of arguable legal merit. Thank you.
Thank you. Well, the court notes in reviewing all the pleadings and especially the defendant's motion that she does not allege or argue anything that was not previously addressed. There's no new information which would cause the court to change the order, and she has not established palpable error whereby the court was misled when the court made a ruling in this matter previously. As a result, the court will deny the motion. Mr. Kelly, you can do an order denying the motion submitted under 7-day. The court is not going to award any attorney fees at this time, but the court will consider that in the future in the event that the issues are in fact brought up again. So, Mr. Kelly, you can prepare the order, submit it, and that will conclude the case. You're free to go. Have a good day.
Thank you, Your Honor.
This is Avery Miller versus Miranda Finley. Plaintiff and defendant are both present.
Hello?
Hello.
I'm trying to get the video. There it goes. Okay.
All right, calling case 2009-4118 DP Miranda Finley versus Avery Miller. Today is Monday, November 25th, 2024 at 10:40 a.m.
Court will note that this matter is before the court on the defendant's emergency motion for an ex parte custody order in this matter. Ma'am, you've alleged a number of things as far as some pending parental kidnapping charges, et cetera, but you've not alleged what happened as a result of those charges. Have the charges concluded in any way?
I haven't heard anything, no.
Okay. Go ahead with your motion. Anything else?
This wasn't my motion. This was his motion.
Okay, I did say it was defendant's motion. I'm sorry, ma'am.
It's okay.
Mr. Miller, go ahead with your motion.
Okay, Your Honor, my name is Avery Miller Graham. I am the father of Alea, Amira, and Akira Miller Graham, the minor children involved in this matter. I'm appearing before the court today in ex parte proceeding to seek immediate relief due to Miranda Finley violating the current parenting time order and engaging in abusive conduct towards our middle child, Amira Miller Graham. I respectfully request that the court issue temporary relief to protect the minor children's safety and to enforce my parenting time rights. The court has jurisdiction over this matter pursuant to MCL 722.27, which governs custody and parenting time in Michigan, and the venue is proper as Calhoun County is where the minor children reside. The parties were previously ordered to follow a parenting time schedule established by the court. However, Miranda has violated this order repeatedly by withholding my parenting time, thinking she is above the court, picking and choosing when I can see my children, and not allowing me to see my children on my weekends or any weekend at all. In addition to violation of the parenting time order, I have serious concerns regarding the safety and well-being of my daughters. Miranda Finley has engaged in abusive conduct towards Amira Miller Graham, including choking, fighting, bullying, taking verbal abuse, taking minor child's phone so she can't call for help. As a result of this abuse, my children do not wish to continue to live with Miranda Finley, are constantly depressed, scared, out of fear of Miss Finley. There's also an ongoing CPS case with Miranda. She hasn't been taking the youngest child, Akira Miller Graham, to school because Miranda was banned from Akira's school due to hysterical, vicious behavior on 4 separate occasions. I request for temporary relief from the court on an emergency basis in order to prevent further harm to the minor children and to enforce parenting time rights. An order requiring Miranda Finley to immediately comply with the parenting time schedule as set forth by the court, temporary custody of the minor child, or at a minimum supervised parenting time until further proceedings can be scheduled. An order directing Miranda Finley to immediately return the minor child's phone, as it is a reasonable expectation for the child to have access to communication with both parents. A temporary protection order to ensure the safety of the minor child if necessary. An order directing Child Protective Services to immediately investigate these allegations of abuse and file a report with the court.
Okay, anything else, sir?
No, that's it.
Okay, well, I will tell you, if CPS if there's a basis, they will investigate and then they will file a report at the conclusion basically of 30 days. So that's if they find that there's any basis for that. So I don't need to order them to do something that they're required to do in any event. What happens is the court will enforce the orders of the court. So if you're not getting parenting time, then the court will enforce that, and that parenting time will be ordered. If a party doesn't comply, they risk going to jail if they don't comply with parenting time. Ma'am, anything else you'd like to say before we conclude?
Yes, sir. So, Avery Miller has brainwashed my 14-year-old into believing that she's not safe. Her phone got took due to her failing grades, not because of her safety. I had recently moved back to Calhoun County, and my kids were going to Lakeview School, but I pulled them out of Lakeview School due to Avery going up there with CPS and acting like he was CPS and interrogating my 10-year-old daughter without my permission regarding that he has no parenting time, he's not on the birth certificate, and he's not on any paperwork. So I'm in the process of transferring their schools due to the safety of my concern for my kids, because he wasn't even supposed to know where my kids went to school at, because since he literally did this as soon as I moved back down here. He has not tried to get my kids since we went to court. He was able to talk to my girls on their own phones whenever he wanted to. He's been riding past my grandma's house harassing me. I just got this court order, so I haven't been able to go down to the courts to file a protection order against him, because I have text messages and everything that I need to send to the court of him threatening me, him calling, like, it's always this. He's always threatening me. He's harassing me. I let him get his kids when he wants to. I let his family get the kids when they want to, until it comes to this. He literally went to my daughter's school and interrogated her, and the school thought that he worked with CPS. So I had an issue with the principal about it, and they put a no trespassing on me because I went up to the school because he pretended that he worked with CPS.
Okay, well, ma'am, you say that he has nothing in this matter that gives him any rights, but the court does note that there was an order for custody and parenting time back on March 22nd or 21st, 2022. So how are you saying that there's no paperwork?
His parenting time was taken because of that.
Taken.
Yes.
Oh my God, the judge couldn't handle it. Oh my God, roll that back. Roll that back.
Or 21st, 2022. So how are you saying that there's no paperwork
His parenting time was taken because of that.
taken?
Yes.
Okay,
Your Honor, can I say something?
go ahead, sir.
I never posed as a CPS worker. I had to meet the CPS worker Nikki Booker that was on the case. I had to meet her at the school because of several failed attempts to meet with Miranda to interrogate, as she calls it, the kids, the minor children. She was dodging Nikki Booker, so I said that I would meet her at the school. Nikki showed them her credentials and everything. I can't pose as a CPS worker and not show them any credentials, and they let me talk to a minor child.
Okay,
And she's right as far as that goes. Like, I'm not able to get any records from the school because the records would indicate that Akira has only been in school maybe 2 weeks, and the school year started months ago.
Because she was going to Lansing school before we moved down here.
okay, let me
Can I
see.
say something else as well before you're done?
Just a minute, ma'am.
I don't understand why we gotta keep going through this and our kids is.
Ma'am, just a minute.
She's so fucking extra. You
I
think
want to
she
get
was
back to the
gum?
order, so I'm pulling the order up.
You think she was gum? And no fun. I bet she's not even good.
Okay, this is the
in
order that
bed.
was dated March 21, 2022.
4 days before my birthday.
It did provide for a suspension of parenting time pending those parental kidnapping charges. And you're saying they haven't been resolved at this point?
No.
Your Honor, they have been resolved. They lessened the charge because it was never me just like taking or kidnapping the kids. It was me not sending them back to the mom on as the court order stated. I was supposed to send them back, and I never sent them back. So that was violating the court order, and it started out a parental kidnapping, but they lessened the charge, and I ended up getting probation and did probation for it.
Okay. Well,
In Kalamazoo County.
what you're gonna have to do, sir, is that order is still in place until it's changed. So as it relates to parenting time, you're gonna have to file a motion for parenting time in this matter, and you're gonna have to set forth the basis for doing it. And then the court will entertain it at that point, but this is a different motion. You're seeking a motion for ex parte custody. Custody is different than parenting time. Anything else, ma'am, before we conclude?
Yes, two things. The CPS case was closed due to no findings, and I wasn't dodging the CPS worker. I got in touch with her, and I also have text messages proving that I was trying to get in touch with her several times, and she canceled on me several times.
Okay. Well, what the court notes in this matter is that the defendant does file the motion in very conclusory terms. There's no allegations of fact on which the court can determine if there is in fact probable cause or change in circumstances sufficient to modify custody. And the request is for modification of custody. And as a result, there's no basis for the court to do that. So I'm going to deny the motion at this time. Ma'am, you're going to have to prepare an order denying the motion. And otherwise, sir, if you wish to have parenting time, you'll have to file a motion for that and set forth facts on which the court should base the finding. So court will conclude this matter. You're free to go. Have a good day.
Thank you.
She will tell that story like she fucking won that case. Like, I told him! And the judge ruled in my favor! He tooken it down. He tooken it there.
Eli Foster. We do not have plaintiff Chelsea Foster in our Please unmute.
Ma'am, don't unmute. Don't unmute! First of all, I have a pet peeve when I knock my phone down. Secondly, I have a pet peeve when my hair has one singular piece. No, we are not having a members only tonight. We'll be having a members only Monday morning. That's tomorrow morning. I know. But I decided that we'll do all tonight together and then members only tomorrow and then regular show tomorrow night. My pet peeve is when I drop my phone, but also when I've done my hair up, but then there's one singular, like that's too much. It's when there's this. And you can't even make it happen. It has to happen on its own. Because oftentimes I do it perfect, but sometimes there's like, no, that's too big. I would feel that. It's just a little piece of hair that you didn't ensnare. Tomorrow's Monday, so tomorrow we'll have 2 shows, approximately 10 a.m. Pacific and 4 p.m. Pacific. 10 to 4, 10 and 4. 10 and 4, 10 4? 10 4. Woo!
Calling case 2024-2701 DM.
Wait, I was distracted. We're going back to hear her say bitch. Say bitch.
Court will conclude this matter. You're free to go. Have a good day.
Thank you.
Was that him or her? Good night, Adam.
Have Eli Foster. We do not have plaintiff Chelsea Foster and her. Please unmute.
Unmute. Unmute.
Calling case 2024-2701 DM Chelsea Foster versus Eli Foster. Today is Monday, November 25th, 2024 at 10:52 a.m.
This matter is before the court on the defendant's motion to determine child born out of wedlock in this particular case. Sir, what we're going to need in this matter is you've not done genetic testing. Is that correct?
Yes, Your Honor.
Okay. What the court will do is the court will order genetic testing between you and the child. And then once we have that testing back, then the court will schedule an evidentiary hearing where we'll take some testimony. Those hearings don't take long. They take maybe 15 minutes to, somewhere in that 15 to 20 minutes. But we're going to need, because there's nothing else in the motion for the court to base it on, the court's going to have to order the genetic testing. That testing will have to be done by a certified lab as well. Sometimes people will want to get those tests done through some kind of a home, genetic.
It's like a home prostitution service that you can get to come and stick the Q-tip down your dick. It's extra. I'll admit that. It costs a lot extra, but you can definitely do that for sure. I'm sure, right? Isn't that the same thing, Courtney? I'm pretty sure that's the same thing. You just stick it down the, Hi, Christy.
Testing, those won't satisfy the evidentiary requirements, so you'll have to go through a lab. If is the child on any public assistance at all? Do you know?
I have no idea, Your Honor.
Okay. What you can do is contact the friend of the court's office, call them and speak to Attorney Magnuson. If the matter qualifies as a 4D case, then you'll be able to get the DNA testing through him, and it's far less expensive than what you'd have to do it independently.
Okay.
Okay? So contact his office, set up that. Once we have the test results in, the court will set a hearing.
Okay, Your Honor.
Okay, okay. Thank you,
A
sir.
4D case is
Have a good
not
day.
one where you
You
have
as
to
well,
take
Your Honor.
4Ds, by the way. Just so you know, a 4D case, not one where you have to take 4Ds.
Court case, I do not have Ramon Guerrero or Jerry Diaz in our waiting room, so we'll call the business court case and then
Well, call this one. It's enough time. We'll call it and then just we'll put it over and then you'll have to renotice it if she wants.
calling
For-
case 2022-2792 DM Ramon Guerrero versus Jerry Diaz. Today is Monday, November 25th, 2024 at 10:55 a.m.
Court will note in this matter, it is now 10:55 a.m. The matter was set for 10:30. In this matter, neither the plaintiff nor the defendant have appeared. The matter is before the court on the defendant's motion to set aside order of affiliation and to revoke affidavit of parentage or acknowledgement of parentage in this particular matter. As the parties are not here, the court cannot proceed. And as a result, the court will not proceed in this matter. If the defendant wishes to proceed, then she'll have to renotice this matter for hearing.
Amazing. Welcome, Raiders. You're here just in time to have a great time with us. Woo! Make sure you hit the like button. Subscribe. Make me happy. Mayor's not here. We don't see him.
If the defendant wishes to. Hold on, we've got to delete the file, renotice this matter for hearing.
Delete what,
Calling case
Judge?
2024-2382 CB HMFM Holdings LLC versus Orphan Education LLC et al. Today is Monday, November 25th, 2024 at 10:56 a.m.
Court will note the appearance of Ms. Nazel, and we gotta delete the file, renotice. Hold on, it's our setup. They've got to delete the. Do you have that done now so we don't get the feedback?
I'm not sure. I think the feedback may be coming from someone.
Is that one of you that's got
Are we
this
good
on
now?
twice?
Yeah. Court will note, as I stated, that Ms. Nazel, you're on behalf of the plaintiffs, correct?
That is correct, Your Honor.
Okay, and then we have Mr. Monroe, you're on behalf of who?
Tarek Muslim.
Okay,
And Your Honor, this is Dave from. I'm on behalf of Orphans Education and Haitham Masri.
okay. I had a Attorney Miller, I think, previously in there. Are they in your office?
He's not in my office, but he is co-counsel.
Okay, got it. Okay. This matter is before the court as stated on the plaintiff's motion for a temporary restraining order and or preliminary injunction. Ms. Nazel, you can proceed.
Thank you, Your Honor. As you stated, this is our motion for a preliminary injunction and a quiet title action with respect to property located on 1007 Industrial Avenue, Albion, Michigan, which is currently being operated as a cannabis grow and harvesting facility. Your Honor, my client has invested $700,000 in reliance representations by the defendants that HMFM Holdings is the rightful owner of the subject property. And given the clear risk of the property and the business operation, the employees, we respectfully request that the court grant our preliminary injunction to preserve the status quo of the business and property until the resolution of the proceedings. Your Honor, I lay out my argument in the motion. I believe the court has already reviewed our motion, hence why they already entered the temporary restraining order. But I would like to just highlight a few facts with respect to the four elements that the court considers to issue a preliminary injunction. With respect to irreparable harm, Your Honor, Michigan courts have long recognized that the potential disposition of real property does constitute as irreparable harm, given that it's a special, it's significant. With respect to this case, Your Honor, the risk is compounded by the ongoing operations of a business, which requires stability to remain compliant with state regulations. If the property and or business operations are disrupted in any way, my client, as well as Mr. Muslim, stand to lose a substantial amount of investments that have gone into the viability of the business. And there's no adequate remedy at law, because monetary damages are, cannot preserve the real property. The defendants won't suffer any prejudice in with respect to a preliminary injunction, maintaining the status quo until the resolution of the case, Your Honor. Muslim, who's a defendant in this case, is a 30% member of HMFM Holdings. He only benefits from the success of the business. And Orphans Education and Mr. Musri have previously agreed to a stipulated order, which demonstrates their cooperation to a resolution. I have attached as exhibit H, the email exchange between me and Mr. Stockram. With respect to public interest, this does serve the public interest of the community. The business employs over 20 staff members who rely on the income that they receive from their work at this business operation and their livelihood, plus the stability of the business ensures compliance with Michigan's cannabis regulations, which is a broader interest of the state and community. The final element, Your Honor, with respect to likelihood of success on the merits, I have attached most of the record that I have in my possession when it came down to this transaction. The evidence strongly supports our claim. I've attached an email as exhibit F from Eric Norden, who represented the defendants prior to my client's involvement, establishing the chain of title. Specifically in that email, it shows that HMFM Holdings is the last title holder and makes no reference to any other interests, specifically Orphans Education or Alethea Realty. Subsequent documents that were exchanged between the parties, I've attached as exhibit K and L. The management service agreement as well as a security agreement establish that HMFM Holdings is the real property owner. With respect to Alethea Realty, who issued a notice to quit upon my client about a month ago. There's an email that was provided by Mr. Stockram from Mr. Norden suggesting that Alethea Realty had relinquished its interest in the property. I don't have the executed documents, Your Honor. We haven't commenced discovery, but I do intend to subpoena Mr. Norden for the entire file during the pendency of this case. We have one party who had agreed. We have three parties, Your Honor, who are contesting the title of the property. Orphans Education and Musri are saying they're the rightful owners. My client, HMFM Holdings, is arguing that they're the rightful owners, and then Alethea Realty, based on their notice to quit, are now stating that they're the landlord. So there are three parties who would benefit from this TRO. Mr. Muslim, who is a member of HMFM Holdings, who is the only party who was opposing the TRO, would also benefit from this because he is a member who benefits from the profits of the business. So at this time, Your Honor, I'm asking the court convert the temporary restraining order into a preliminary injunction for the pendency of this case.
Okay. Why don't we go with you, Mr. Monroe, first? You had agreed to a temporary restraining order, so I take it you don't oppose the preliminary injunction at this time.
I never agreed to a temporary restraining order.
Oh,
It was Mr. Stockram, Your Honor, Dan Stockram.
okay. I'm
Your
sorry.
Your Honor, I did not agree to. We agreed to provide an order. That order was circulated. It was never signed. And when Mr. Monroe began representing, we had a discussion, and that order was never entered or agreed to.
Okay, well, good. You clarified. I guess that's contrary to what the plaintiff had alleged.
That's true.
Mr. Monroe, go ahead.
Well, there are a few things that I think that I need to bring to the court's attention, but let me start off with what counsel for the plaintiff is not telling you, either because she doesn't know or because she's just not doing it. March
Oh my god, the shade! The absolute shade that he just threw! Did you see that? MB, I love you so much. I love you so much. Thank you so much for being here. I seriously have been thinking about you. That was fucking beyond shade. I know you remember this case. It went on with the guy with the standing desk. Oh. Us who love the boring, quote unquote, parts of law just love these cases. I know it's niche, but if the internet is not for loving niche things, what is it for? It is the same case, MB. It must be prior. It's November of 2024. You know, time is sort of running together. It turns out I've done 750 episodes on this channel. Don't know when that happened, but I did. So I'm having a hard time keeping track of each one of them, but you know, maybe there's an AI for that.
30th of 2022, there was a land contract executed between HM/FM LLC as seller and Alethea Realty LLC as buyer. So the equitable title of the property, and just so that the record's clear, when I refer to the property, I'm talking about the industrial property known as 1007 Industrial Boulevard. The equitable title was transferred to Alethea Realty under the land contract. On September 18, 2023, the seller, HM/FM LLC, made an assignment of land contract interest between itself and transferred that to Orphans Education LLC. So that at that moment, HM/FM LLC had neither the legal ownership nor the equitable ownership. It still was listed as the record owner with the Register of Deeds, but it had no interest in the real estate, having assigned its vendor's interest and had already sold the vendee's interest. So on March 14, 2024, Mr. Eric Norden, an attorney, sent an email.
Hold on, orphan education. I mean, I'm not trying to be a conspiracy theorist here, and we all know I love smoking weed. I am high right now. I love it. But I live in Canada where it's regulated, and so calling your shit orphans education wouldn't really fly. It would be like, yuck, I don't want to smoke orphans education. But perhaps it's a way to get somebody stupid to stop looking at your business. Like, can you, because I Googled it and it like gets lost in amongst searching for orphan education, which weirdly enough is a big search term.
With documents explaining this and giving Mr. I can't pronounce his last name. He goes by Mo, but the plaintiff, explaining to the plaintiff through these documents the status of ownership, the fact that there was a land contract between HM/FM and Alethea, and that Alethea, or that HM/FM was not the owner of, or that it had already assigned the seller's interest in the land contract. So that excuse me. So none of this is in the complaint. None of it is in the before the court, either in the amended complaint, the original complaint, or in plaintiff's motion. I called Chambers last week to see whether or not you would today take witnesses or exhibits, and I was told that typically you would schedule an evidentiary hearing at some time in the future if you thought it was necessary. So what plaintiff is attempting to do is to say that HMFM LLC owns the property when it doesn't, and that Alethea Realty has no right to obtain possession or rent, which it does because it is the equitable owner of the property. And there are documents that we can introduce. There are witnesses that will bring those documents into the court. This will defeat both the complaint, the amended complaint, and this TRO. So there are a couple of other things I'd like to bring to the court's attention. The TRO, neither I nor Dan were given any notice or given copies of the TRO motion or the proposed restraining order. What we got was an email that said attached are these documents, but they were not attached. And we did not get copies of the documents, the TRO motion or the order, until after the court entered it. Michigan Court Rule 3.310 says that, by affidavit, plaintiff has to show why notice wasn't given to us and why we were not permitted to be heard by the court.
Because ex parte TPOs or TROs, that's what they fucking do, bro. I mean, sir. Even I know that. They enter ex parte motions, and that's why when somebody, and this is why during the Johnny Depp trial, yeah, we're going back to the Johnny Depp trial, it was such absolute shade when they tried to claim that she had a TPO against him, and it was a fucking ex parte TPO. I'm sorry. We all know that's barely as good as the fucking paper it's written on until you get in front of a real judge. And you know what I'm saying? Anyways, also, Christy, I'm so glad you're here and having a good time. We're having a good time. It's my Friday. And look, we have a lot left tonight. We're having a long night, so buckle up. Also, MB, I completely understand about exercising and then wanting to smoke. In fact, the reason I like working out at home is because I can vape on my vape pen all the time, which is terrible for my stamina, I guess, but whatever, realistic.
Court in opposition of the entry of the TRO. The other issue is that this is property that is valuable, that the plaintiff, Mo, had agreed to pay $25,000 a month to possess. And we've got that, and he's not paying anything, which is why I sent a termination notice that would be heard in the district court to terminate tenancy for failure. Well, I did the 30-day notice, but he hasn't been paying any rent. The business is not paying any rent. And there's an agreement that it was going to be $25,000 a month. No, that's nowhere in the complaint, the amended complaint, or in the pleadings to get this TRO. I want to speak for a moment about the amended complaint. The amended complaint was filed on the 15th. And it was filed without permission of the court, no motion, no order of the court permitted this filing. The defendants had filed an answer, and if you go 14 days from the date of that answer, the plaintiff could file an amended complaint within or on or before the 11th of the month. The 11th was Veterans Day, so they had until the 12th. It wasn't filed until the 15th. So I don't know. I mean, there is no amended complaint. It was improperly filed. Plaintiff got the court to issue a summons, which is in violation of law. So, I mean, that's a problem. So I would request an evidentiary hearing so that the court can be fully informed, have time to review the documents. I don't believe that Alethea was served. Alethea Realty was served. They're a critical party. But I also don't believe that they're a party to the lawsuit because they were added in the amended.
They're a critical party, they weren't served, but they're also not a part of the lawsuit, Judge. That's right. They're so important, they're not even part of it.
Complaint, which was improperly filed with the court, and the summons is illegal.
Okay, thank you. Mr. Stockram, what's your position?
Your Honor, just a very brief background on what's really going on here. This was a transaction that was handled by one attorney for both sides. The fraud that is being suggested here was documents that were given to both parties that evidence that there was going to be a transaction wherein the real estate owner would collect rent or get land contract payments, and that the plaintiff would be operating a cannabis facility on that property. The only document that got signed out of all the documents, that attorney that was representing both parties, was the operating agreement that supposedly gave the plaintiff a 70% interest. Now, were a number of documents, guarantees, amendment to land contract, all of the documents that were being suggested in the pleadings that the plaintiff was not aware of were either drafted by or given to him by his attorney, that he now suggests he was defrauded. But the whole reason that you're here, Your Honor, is very simple. They agreed to allow him to install his equipment and begin operations prior to the actual license being issued. The whole purpose of him delaying on the document signing was supposedly because he wanted to make sure the license was issued. Once the license was issued, the only document that he recognized and the only document in these pleadings that plaintiff decided to tell you about is the operating agreement that said he now has 70% of the ownership. If you believe what's going on here, you would believe that he is now 70% owner of a property that's potentially worth $1 million without paying a dime. That the defendants basically gave him the property so he could go operate his own business in that property. The reason we're here, Your Honor, is because he's now operating it. It's generating every 2 to 3 weeks $150,000 to $200,000 worth of cannabis. The purpose of this restraining order and the purpose of continuing the injunction is only to make sure that he continues to operate this property and take the revenues from this property, none of which have been paid neither to the minority member of that operating agreement or to the plaintiff that owned the property. So right now, they're asking you to continue the delay and enjoin a district court that has jurisdiction over a matter like this, just so that they continue to operate as long as possible to take as much money and cannabis from that property as possible until supposedly a resolution, which, given the number of documents, and you can see there's a number of documents to review, there's different things. But Your Honor, they're basically telling this court that we filed this in good faith when in actuality, this is a delay tactic. They demanded mediation from the other defendant. They've requested that I consent to mediation. And the only purpose that you're here is to make sure this goes on as long as possible. And while my client gets no payment on the lease, no payment on a land contract, no payment whatsoever for the property that is worth $1 million that he is now operating in. That's why we're here. We're not here because there's a number of technical things that we have to talk about or procedural things. They're asking you to help them delay this for as long as possible so that they have enough money out of this at the time so that the longer it goes, the more money they get. And they are not paying one dime to anybody, and they're occupying the defendant's property. So the idea that this is some benefit to all the parties is just simply not true. My client is getting absolutely nothing for their $1 million investment while they're in the property operating. And the attorney that handled this transaction, just as a slight bit of background, was representing both parties. And the moment that the plaintiff signed off on that one agreement, even though he had a half a dozen agreements with it that were supposed to be signed to structure this transaction, only signed the one that puts this in front of you that says he's 70% owner. That's the fraud that we're talking about. We're not talking about any other fraud. All of the documents that are suggested here that supposedly were done in fraud were all documents he was aware of and knew about. So granting a TRO only serves to disadvantage my client, to financially burden him further, and to extend this and give leverage, which is what this is for, is to give leverage to the plaintiff so that we will be required to grant him a settlement. He did put equipment in that property under the agreement that he was supposed to sign that he never signed other than the one document that gave him a legal advantage. So at this point, he's not the owner, but he is occupying, but he's not leasing. I don't know of any transaction whatsoever that is handled this way where the parties in there has been in there since, and they're asking for an emergency TRO from you when they've been in that property since July. Only at this moment do they say, hey, wait a minute, we need a TRO when they've already been in there operating for months. So there is no emergency here, Your Honor. This is just a matter of they do not want this litigated anytime soon. So as long as they're receiving their money, and they provide no accounting, they've given no money to the minority operating agreement member. They've given no money to the person that owned the property. The only thing they've done is grow marijuana, distribute it, and take the funds. And that's what's happening every week to the tune of $150,000 to $200,000 in revenues. So in making your decision, Your Honor, if you decide that this order needs to go forward, then at least grant the defendants an accounting for what they've been doing, because there has been not one single piece of paper to say what they've been making, how much they've been making, what share would go to the other defendant, or what would ever be going to my client. They're posturing that my client that owned this and owns it now is not entitled to any money whatsoever and will never get any money. So extending this does no purpose whatsoever other than to delay your court from making a decision on this matter. That is not something that doesn't prejudice my client.
Your Honor, may I?
Yep, go ahead.
I'm first going to,
Let me ask you first on this.
Yes.
Mr. Monroe stated that there was a land contract back in 2022, and then the assignment of the land contract in 2023. Do you acknowledge that or not?
No, Your Honor, we don't acknowledge that. We acknowledge that I received documents with the land contract and assignment, but we question the validity of those documents given the email correspondence. The issue is, Your Honor, if I may, with respect to Mr. Monroe's allegations, first, I would like to address his allegations with respect to my improper filing of the amended complaint and summons.
I don't need to address that. Address
Okay.
the substance of of the argument.
Thank you, Your Honor. Just given that there's no motion to strike. With respect to Mr. Monroe's argument that there's a land contract, we're questioning the validity of that land contract. We received a plethora of transactional documents and email correspondence from Mr. Stockram after the filing of this lawsuit. A review of those documents established that certain documents were not created until August of 2024. When I asked Mr. Stockram, when were these documents created? He had indicated, well, they were executed in May of 2022, and he sent me an email saying, here's the evidence to establish that there's a land contract. Okay, if we take that as truth, then why did you not represent to my client that there's an equitable interest of Alethea Realty, and the ownership interest is now assigned to Orphans Education? Why did you send my client a chain of title without mentioning any of their interests? And Mr. Muslim and Mr. Mosley were both copied to the emails that Mr. Norden would send Mr. Khatib. Mr. Monroe now says that there's this email where or Eric Norden, their prior attorney, had mentioned all of this. Your Honor, I'm looking at the email. He doesn't mention any of this. The very email that Mr. Monroe is alluding to. He talks about about 1007 Management LLC, which is not a party in this case. In fact, he mentions that Alethea Realty relinquished its rights to the land contract. I don't have the executed document. We need some discovery on that. But we don't believe Alethea Realty ever had an interest. In fact, the only time we found out that Alethea Realty existed is when we received the notice to quit after the filing of this lawsuit. So when we dug in further and we reviewed the emails, there's an email from the attorney saying, here is a document relinquishing the rights of Alethea Realty. Your Honor, then I called the Cannabis Regulatory Affairs and I FOIA'd certain documents. The documents that the defendant submitted to the state prior to my client's involvement state that HMFM Holdings is the real property owner. So who are the defendants defrauding? My client or the state or their attorney? I have no idea. But with respect to another allegation, there's a lease agreement. I was never provided a lease agreement stating that there's a $25,000 payment to be owed to Alethea or Orphans Education. They're both mentioning a lease agreement. So I don't know who the lease agreement is for. Mr. Stockram just said he hasn't paid lease. Is it Orphans Education that gets the lease, or is it Alethea Realty now gets the lease payments? But I've never been provided a document to establish the lease terms or the lease payments. With respect to financial harm, Your Honor, I will agree with this court. I will stipulate that we will provide an accounting per our prior stipulated order with respect to any money derived out of this business. And I told Mr. Stockram we'll agree to this, but I'm not entirely sure why Dr. Musri is requiring the accounting. He has nothing to do with HMFM Holdings. I will provide the accounting to the members, and that's Mr. Muslim. So I will stipulate that if this court grants our request for a preliminary injunction, then my HMFM Holdings will provide an accounting to the parties on a monthly basis with respect to any sales of, with respect to anything going on with the business, as Mr. Muslim is entitled to. We never rejected that request. They indicated that we're trying to delay the court from both parties, which is prejudicial to them. Your Honor, I did not file an ex parte motion when we filed this lawsuit. Initially, we were working in good faith, as evidenced in the emails that I've provided to you between me and Mr. Stockram. Although we didn't agree to a final order, Mr. Stockram and I were entertaining a stipulated order to maintain status quo in order for us to mediate. It's not only Mr. Monroe, when Mr. Monroe joined in and representing Muslim, who's a 30% member, who opposed it. If the court would like further, in addition to an accounting, we will preserve any profits made out of the business in order for Mr. Muslim to feel some security. But he hasn't demanded any records. He's cut off communication with Mr. Khatib completely. At this point, I don't believe it's a delay. I believe it's peace of mind for all parties in order to litigate this issue. It is a complex transaction. A lot of documents were exchanged. All three attorneys that appear before this court were not part of those transactions. Eric Norden's testimony, as well as subpoena of documents, is necessary for us to discover and litigate the issues at hand.
Okay, thank you. Mr. Monroe, your response.
So, plaintiff's counsel is saying that she has a copy of the email that I'm referring to from Eric Norden. If it is the March 14th, 2024 email from Eric Norden to her client and to my client, it attached 4 documents. And one of those documents was entitled Superseding Amendment to Land Contract. And the first paragraph says, this superseding amendment to land contract supersedes and replaces the land contract between HM FM Holdings and Alethea Realty effective March 2, 2022. So when counsel says that she was unaware of any land contract with Alethea, or that she didn't know anything about Alethea before the notice to quit was served on her client, she admits that she has a copy of this lawsuit. She's actually attached a couple of documents that were attached to this land contract to her motion, to her TRO motion. And I'm sure that she has this superseding amendment to land contract. While she didn't call it that, she's referred to the fact that the purpose of this agreement was to reduce the sale price and also to replace the vendor and the vendee's interests, or the named vendor and the named vendee. So, and again, if we had an evidentiary hearing, all of this would come in and the court would be very clear as to what is actually going on, which Dan was, I thought, very effective in describing. So.
Thank you. Mr. Stockram, anything else?
No, Your Honor, I believe you understand.
Okay. Well, it does appear in this matter, the court notes, obviously there's a dispute as to ownership, and that does appear to be very clear. So the court cannot say that there's a likelihood of success on the merits if there's a dispute on that. The court will hear an expedited evidentiary hearing. I'm going to have my staff get in touch with all 3 of you, and we'll set that up for next month in December. I will tell you, you're going to have to be flexible because I want it heard that quickly. And if in fact we cannot get everybody on board for a hearing date in December, then we'll just set a date and then everybody will have to appear at that particular time, because I want to get this resolved. But in this particular matter, the court cannot at this time determine that it's appropriate to grant a preliminary injunction, so I will not do so until such time as we have the evidentiary hearing. So we will be in touch with the 3 of you and set that up for a hearing. The hearing will be start at 8:30. And we'll do a full day hearing if we have to, and we'll have all of your documents. I would ask that the attorneys would at that hearing exchange all the documents with the other attorneys prior to that hearing so that they have those, and also provide paper copies to the court, because I'll want to have those rather than having to be online, et cetera. That's just more difficult to follow those. So we will be in touch with all of your offices probably tomorrow or the day after and try to get a date to have this heard, and then be ready to proceed on that day.
Your Honor, 2 questions.
Yes,
First question, will this be an in-person evidentiary hearing?
up to you. If you want to have it in person, we can have it in person. If you prefer to do it Zoom, we'll do it that way. It doesn't matter to the court.
I'll confer with brother counsel. Second, will the temporary restraining order be continued until that evidentiary
It will
hearing?
not. I'm not going to continue that until the evidentiary hearing. Mr. Monroe, I'll ask, because you were kind of more vocal on that, I'll ask that you would do an order stating that the court is not continuing that and would not enter a preliminary injunction at this time.
Okay, I would be happy to do that. Judge, just one more question or request, and that would be that I'd like to be able to, before the hearing, to take the plaintiff Mo's deposition, if the court would order that.
Ms. Nazel, do you have any problem with the deposition before that hearing?
So long as I can take his client's deposition as well.
Okay, why don't you schedule the both of those? It looks like we're gonna have to schedule the hearing later in December, but we'll get it in around the holidays, so let's see, we can make it work in your schedules, okay?
Okay, thank you.
Okay, thank you. You can put that in the order that those parties would submit to their depositions prior to the evidentiary hearing.
Judge, I was looking at your resume online, and looks like you and I went to Michigan State the same time.
Okay,
I was in Case, but
I was over in Acres, so we don't want to dredge up all how many years that's been, okay?
well, I just thank God that we didn't have videos and smartphones back then, because we'd have some explaining to do today.
Not me, I was a model student, so I wouldn't have to explain that. Okay, thanks, we'll be in touch with you.
Thanks,
Thank you.
Judge.
Okay. Have a good day.
You as well,
All
Your
right.
Honor. Thank you very much.
All right, thank you. Let's move on to the PPOs here, Judge. I want to start with Hausman and West and Jones because I don't have Cole Kleins in the other one.
Let's finish it up without any brown nosing. Oh my God. Mr.
Yeah, I don't
Monroe,
have the
wipe your
defendant, yeah,
nose.
Cole Kleins. Okay, please unmute both of you. We really appreciate your patience and we apologize for the delay. Can you hear me, Mr. Jones?
Yes, I can.
Okay, we're calling your case. This is 2024-2648 PP, Samantha Hausman versus Robert Westworth Jones. It is Monday, November 25th, 2024 at 11:32 a.m.
Okay. This matter is before the court on the petitioner's motion to terminate the personal protective order. Ms. Hausman, in this matter, you're seeking to terminate that. Is that what you want to do, ma'am?
Yes, sir. That's exactly what I want to do.
Okay. You understand that, again, if that you don't have that, you will not have the protection of that at this time.
Yes, I understand.
You understand as well that at any time, should it be necessary, you have a right to then file and seek out a personal protective order at some later date if you wish to do so. And I mean, later, it could be tomorrow, it could be a year from now, 5 years from now, whenever you might possibly need that. You understand that?
Yes, I do.
Okay. And are you doing this freely and voluntarily?
Can you repeat that?
Are you doing this freely and voluntarily?
Oh, yes, I am, sir.
Okay. Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to terminate the personal protective order?
No, not at all.
Thank you. Mr. Westworth Jones, I don't assume you're disputing this.
No, I'm not.
Okay. Well, with that in mind, the court does note that Ms. Hausman has here and testified that she wishes to terminate that. She has the right to do so. The court will terminate the personal protective order. The court finds her to be to freely and voluntarily do so, that she's not under any threats or any pressure or anything else that would force her to again terminate the personal protective order, and that she's freely and voluntarily doing it. So the court will terminate that effective today's date. So it will take a little bit of time to get in the computer, but it should be by later today. It should be in there and it should be taken care of. So, okay.
Thank you so much.
Okay. Thank you. You're free to go. Have a good day.
Thank you.
All right, thank you. Let's move on
He looks
here.
less than enthused.
Judge, we're gonna take the pro-con first for Kleins. Is it, I
Okay.
do not have the
Jesus,
Defendant
I've missed
here.
you so.
police will preserve the proofs there. Can please unmute both of you?
Oh, I wish I had
Good
Miss
morning.
Klein's
Good
body
morning.
of hair.
Okay, thank you for your
Oh,
patience. We're gonna do the pro confesso first. So it's 2024 1982 DM, Alyssa Kleins versus Cole Kleins. It's Monday, November 25th, 2024 at 11:34 a.m. Attorney Henderson for the plaintiff. I do not have the defendant or their counsel.
Ms. Kleins, in this matter, we're going to take some testimony from you. So if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay, go ahead, Ms. Henderson.
Thank you. Could you please state your full name and spell your last name for the record?
Elisa Renee Kleins, Klines.
Did you consult with myself regarding filing for a divorce in the summer of 2024?
Yes.
And have I prepared all the necessary paperwork to initiate the process on your behalf?
Yes.
Did you have a chance to review that paperwork prior to signing it?
Yes.
At the time of filing the complaint for divorce, have you resided in Calhoun County for 10 days and the state of Michigan for 180 days?
Yes.
And in the complaint, you stated that there has been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage could be preserved. Could you please state to the court briefly what happened to your marriage?
We drifted apart and
That's a song! MB, we love you so much. So much. I'll be on the next 3 nights if you can make it. I hope you have a great month. Thanks for spending some time with us. And thank you for the super chat, baby. Baby. I love you so much, MB, baby. I love you guys. Seriously, take care, MB. Be safe. Also, is Courtney still here? Courtney, baby, Courtney.
and we found different paths that we need to take that will better ourselves and our kids.
And were all allegations in your complaint true at the time of filing?
Yes.
Do they still remain true today?
Yes.
In the complaint, you stated you have 3 minor children, and it's my understanding that you and Mr. Kleins have reached an agreement regarding custody, parenting time, and child support. Is that correct?
Correct.
And in fact, you have employed Dr. Haugen to render his recommendations on legal custody. Is that correct?
Correct.
And is it true that I am in the process of preparing the judgment consistent with those recommendations?
Yes.
Are you currently pregnant?
No.
If the judge were not to grant the divorce at the time of the expiration of the waiting period, is there any reasonable likelihood that you and Mr. Kleins will go back to living as husband and wife?
No.
May it please the court, Your Honor.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending receipt of the paperwork and the running of the time frame. So, ma'am, you're not divorced until we actually sign all of that paperwork, which still may take a matter of some period of time. In this case, probably we're looking at about a month and a half or so. But at that time, we'll be able to conclude it. So best of luck to you. I hope everything works out for you. We will now call the PPO case.
Thank you,
Yes,
Your
and I'll
Honor.
let you, and you can now go, Anya.
Yeah, I do not
case.
represent the petitioner on the PPO, Your Honor, but
okay.
we have worked together with Mr. Kleins. He accepted service from my office. It's my understanding that he does not contest the termination of the PPO simply because the parents want to attend their children's events together.
Okay.
Okay?
Ms. Henderson, you can leave if you wish, and I'll have some other questions from Ms. Klein.
Thank you very much. Have a good day.
Thank you.
All right, very good. Now this is for the PPO case 2024-1284 PP, Alyssa Kleins versus Cole Kleins. The defendant respondent is not here.
Okay. Ms. Kleins, in this matter, you file a petition seeking to terminate the personal protective order previously rendered in this matter. You understand if you terminate that personal protective order, you won't have the protection of the order.
Correct.
You understand as well that should you need it in the future, I say future, it could be tomorrow, it could be a month from now, a year from now, 5 years from now, you have every right to come in and petition for a personal protective order at that time.
Okay.
Are you seeking to terminate this, and are you doing so freely and voluntarily?
Correct, yes.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to terminate this personal protective?
No.
Okay. Court will find that Ms. Kleins does freely and voluntarily waive and again, seek to terminate the personal protective order, that she's not under any pressure, any coercion, anything else that would again force her to do so. And the court will find that she is freely and voluntarily waiving and agreeing to terminate the personal protective order. So the court will do so. It will take probably a period of time. It'll probably be later today before all the paperwork catches up. But at that time, the matter will be terminated and vacated. Okay, anything else, Ms. Kleins?
No, thank you very much.
Okay, thank you. You're free to go. Have a great.
Snapped me right out of my little daydream there. Just so you guys know, when I daydream, I don't see anything in my mind because I'm fucked up. I'm fucked up, that's what they say. Or sometimes you're a mess. Actually, that's what I often hear. You're a mess, lady. You're a mess. Anyways, you guys, what a nice night we had. Thank you for hanging out with me on my Friday. What do I know? How do I know I'm daydreaming? Because just the same way I think. All the voices in my head. Oh, I wasn't thinking about nothing. Not even close. But when I think about it, I just don't see it. But I still think about it. Anyways. Boom. Here we go. That's right. We'll be back tomorrow morning, 10 a.m. Pacific. We're going to try and hop onto the TPO. I'm going to try and do it fucking live. Because I'm crazy like that. I'm a crazy bitch like that. But we'll see. I sort of want to get a pizza for dinner. Ugh. Don't you guys want pizza for dinner? I sort of do. I sort of do. I love you guys so much. Remember that. Oh my god, my hair. Don't be surprised if one day I come back and my hair is all cut off. But I won't cut you guys off. I would never do that to you. Anyways, I love you so much. Everyone, please be safe wherever you are. Remember that I love you and I'm proud of you. And I will see you in the next video. Okay, bye.
Ways down and ready to ride.